All right, so thank you very much. Apologies for the brief delay. It must be me. I have magnetic hands. I've managed to kill hard drives. You know, I've managed to do this to 3 laptops in one day, just touching my hands. It's sort of the reverse of what was the King's disease?
Midas.
Huh?
Midas.
No, scrofula. Wasn't it the King's touch would cure you? Right. So no, I'm the reverse. I cause the disease. All right. This is a jointly authored work. Gideon is not here, and so therefore I'm going to blame him for each and every one of the errors that you may discover in this paper. This is a long-standing tradition, so he'll forgive me, I hope. Okay, let me give you the very, very briefest version of what it is that we're trying to do here. Leave as much time as possible for comments. So there's 2 aims here. There's one that's theoretical, one that's doctrinal. The theoretical aim is to try to provide a different explanation for the function of fair use doctrine. We'll get to what it is in a moment. And there's a doctrinal payoff. We think this theory gives us a different way of dealing with the cases that may or may not be better. I hope I will convince you it's better. Now, here's the background for the paper. This is the general understanding of the way we look at fair use. Copyright, or at least this is the economic theory of copyright. Copyright is a grant of particular private property rights to authors in order to incentivize them to create. And we have an entire list within the statute of specific carve-outs or exceptions to those large grants, to the large grant of rights to the author. They appear for different reasons, and if you want, there's 2 explanations for why these carve-outs appear. One of them is an unhappy explanation. They appear there because the reason that one may perform a work in a state fair under a mandatory license is because some public choice explanation. There's other ones. They're more straightforward. It's not entirely clear that the statutory language is best drafted to achieve this in all cases, but the other explanation you have is that there are certain kinds of transactions that we expect will be blocked by high transaction costs, and we have these exceptions where, notwithstanding the fact that it's ordinarily within the author's rights, we grant a particular kind of license to take care of our particular kind of transaction. Now, against that background, the standard the dominant theory of what it is that we're trying to accomplish in the fair use doctrine that's associated with an article of Wendy Gordon's, although she somewhat expanded her view of the fair use doctrine, so I don't call it the Wendy Gordon theory. We'll call it the Wendy Gordon theory with the understanding that the Wendy Gordon theory is actually fairly larger than I'm giving you credit for here. But the theory here is along the lines of fair use is there to take care of certain kinds of, it's a generalized transaction cost exception. It's there to take care of certain kinds of transactions we want to see take place, but they won't take place because of high transaction costs. And the article actually came out at the time of the Sony decision. The Sony decision is a great illustration of a transaction cost problem, right? Imagine all the movie studios trying to negotiate with individual licenses with all these home users. All right. Now, that's the dominant theory. Our theory of what it is that fair use is trying to do is somewhat different. What we say is that a different way of seeing what the scheme is trying to do of exceptions plus grants of rights is it's a way of calibrating incentives. Okay, so We could, if you want, we could start, we could as an alternative, if we wanted to incentivize, we could offer many fewer rights or rights that were more limited in time, but that's not what we do. What we do is we grant vast rights, then a vast exception along with it. The fair use is this vast exception that goes along with it, or if you like, it's better, if you want to think of it this way, think of it as there's actually two grants out there that happen at the same time. There's the grant of rights to the author and the grant of these use privileges to everyone else. And this is the way of calibrating the incentives so that we don't grant greater monopoly rights than is necessary in order to incentivize. Now, there's something nice about doing it in this way, rather than doing it in the form of smaller rights, and it is that by granting these privileges to the users at large, if we do this right, we're in fact taking care of, or we're creating, we're carving out of the incentives those kinds of things that are of greater public value, if you want to put it that way. We're focusing the rights that we're giving to the author to a particular narrow set that's of less interest to the public at large. Now, what do I mean by the public at large? What we suggest is that what you think of as the grant to the public is a set of privileged uses where those uses are ones with widespread non-pecuniary follow-on benefits. The focus here is on follow-on benefits to the non-user, right? I'll give you some illustrations in a moment, and hopefully this will be clearer. But the idea is it's not the person that is using the copyrighted expression that is earning the utility, but other parties beyond this user. And the idea here is not per se there might be a transaction cost problem. There might, by the way, be a transaction cost problem in this kind of instance if you have many users, many beneficiaries beyond the initial user. But from our point of view, it doesn't make a difference whether the transaction could or could not take place. Even if it could take place, there's no reason in the first place to include this in the grant of rights to the author. This is an allocational tool, and so for certain ones, just if there is the benefit, it just makes sense at the outset to allocate directly to the user. Okay, so I will try to explain this by way of some examples. Let me just get to the doctrinal bit, and then the examples I hope will show what it is that we're trying to do. The doctrinal bit is this. If you take the idea that what we're trying to do with fair use is this vast grant of privileged uses to users, then the court's approach should be fairly simple. It should try to figure out, are we within the realm of the exclusive rights to the author, or are we within the realm of the grant of privileged uses to the user? Unfortunately, there is some incommensurability here. But the way to handle this would be to ask, is this particular use within a category of presumptively fair uses? And I will give you some in a moment. If it is, then it is a fair use, right? And we can stop right there except for one question. And the one question we have to ask is, if we recognize this use as fair, is this going to eliminate the incentives of creating this work? If it's not going to, then it is fair in preempts. If it is going to, it's not fair because we don't, the only thing we're trying to make sure we do is we don't cut back all the way to zero incentives. All right. So here, let me give you some examples. Hopefully, this will help illustrate this. Okay, so let's start with some political uses. Okay, political uses of works. I think you can say is fairly straightforwardly cases where there are widespread non-pecuniary benefits to the non-users. That is, at least if you believe all the fine things that you see in the literatures on First Amendment, free speech, and democratic governance, and the like. So let me give you an example of something that in our, let me give you an example of a use, and let's see how it would be handled in our scheme. Right? Political candidate A writes an autobiography. Political candidate B thinks this autobiography actually has devastating material about political candidate A and should be used against that the candidate. Political candidate B starts distributing the political A's autobiography. Right? Now, is this a presumptively fair use? In our book, yes. Right? This is a political use that you have. It enhances the democratic process, et cetera, et cetera. The only question is, will the distribution of this work by political candidate B eliminate, if we have this as a fair use, will this eliminate the incentives for the creation of political candidate A's autobiography? There we have a little bit of a fact-intensive inquiry, but I would say less fact-intensive than some of the ones that you have today. We'll come to the conclusion either yes, it will, no, it won't. And on that basis, we'll either say yes, it is, or is not a fair use. Now, I think it's fairly clear that under today's doctrine, it would never be found as a fair use. If you want an easier one, right? Can I use a popular song in my campaign commercials? The answer almost certainly is yes, right? In our view, if you want to think about some of the other cases where it sort of will stand out how this will work out differently. Think of all the cases dealing with parodies versus satires. And in our view, that these cases have got this almost entirely wrong. Right? They've got an opposite. Well, we're interested, if you have a work that is satirized in order to create some political commentary, right? The cat not in the hat in order to make some comment about the O.J. Simpson trial. That's a perfect fair use in our book. We don't really care whether it transforms, doesn't transform. That's not the issue, right? The issue is this the kind of thing which is within the presumptively privileged uses for the public? Yes, it is. Does it eliminate the incentives to create the cat in the hat? Obviously not. The end, as far as we're concerned. Okay, there's some other cases I will mention briefly, just to sort of play out the way it works in doctrine. Think of the Texaco case, right? You have photocopying of articles for research purposes. So basically, research is another one of these things where it's fairly clear. If you want fact-seeking uses of copyrighted works would be fairly clear, presumptive fair uses because of the follow-on non-pecuniary benefits. So what do we think of the Texaco case? If you're photocopying these articles in order to facilitate your future research, clearly a presumptively fair use. The only interesting question is whether it will eliminate the market for producing these dry academic articles. When I would teach this class, I would like to put up these 50-word titles to articles that you'd see in the American Geophysical, whatever the name of the journal was. Now, so it would seem, again, fairly clearly fair use. I will, in a moment, just cut back in this a little bit. I am oversimplifying one aspect that I will talk about in a moment. You know what, since time is short, I will jump straight to my clarification. I'll just say that there is a role in our doctrine for utilizing the existing four-factor test. We would do it a little bit differently, and it points out the one bit that I've been oversimplifying so far. So here we have two pieces again that we're all interested in. We're only interested in identifying, is it a presumptively fair use? If it is, then case over, unless we determine that incentives are eliminated. We can slot the 4 factors into this inquiry. Right? So what we would say is when you look at the purpose and nature of the fair use and the amount of substantiality of the portion used, what you're looking at is the question of, is this in fact a presumptively fair use? Right? Now, what is the purpose of the use? Politics, fact-seeking, et cetera, et cetera. Oh, that's good. Amount and substantiality of portion used, the inquiry here is essentially, do we believe you? This is a good faith test. Can you accomplish your goal of mocking candidate A by distributing 6 chapters of candidate A's work, or 2 chapters, or do you in fact need to distribute the entirety of candidate A's work? If you don't need to, if you accomplish the same goal by giving out the 2 chapters, then we no longer believe you that the use is fair when you give out the entire work. And we can say by the same thing for the Texaco case, right? Do you in fact, does it facilitate your research by archivally copying these articles or not? I think, I'm biased here since I do this. Don't tell anyone. I would say yes, but you know, there's we can argue about whether it's in fact that is the real reason of the use. Now, once we've agreed that the other 2 factors simply talk about whether there's going to be, we're going to, by allowing this fair use, completely undermine the production of the work. Right, so here the effect of the use in the market. The market analysis we're here interested in is very small. It's simply, it's yes, no, right? Not is the author going to lose money, but is the author going to lose so much that the author would never produce this kind of work? And this is related to the same way to the type of the copyrighted work. We're interested only yes, no question. Is this the kind of thing that we'd see anyway, or is it that we need to protect this kind of use for the author? I have all sorts of other gobbledygook I can add, but I will run out of time. So instead, don't throw any tomatoes, please. Yes.
Okay. So as I look around the room, I see that almost all of us had written on fair use are going to shortly.
Yes.
So we're probably all thinking the same thing I'm thinking.
Yes.
All the good parts of your analysis I've already written. Everything I don't like is just wrong.
All right, so thank you very much.
I just have one small question. So your second step is preserving the incentives. And I'm wondering if you're saying that wrong, because what you just said is not preserving the incentives, it's preserving the creation of the works.
It shouldn't be preserving incentives. Preserving sufficient incentives that this would be created. That's it. So you can cut back on incentives. We want to cut back.
You're looking really creative out.
We believe there's incentivizing baked into the code, and that's what fair use is cutting back on. So yes. Yeah.
Okay. What I like about your proposal and the way you're looking at it is that it really does mesh with how moral rights should be used and how it's not being used in the U.S. Because in the U.S., our Visual Arts Rights Act says that it's subject to fair use. There is subject to fair use. That's always struck me as completely wrong. They're two different completely entities, and the way you're looking at fair use, I think, reinforces that. So I really like that aspect of what you're doing. Minor point under amount and substantiality of the portion used, and you have to think under that. I sort of think there's a lot of substantiation for that factor really also going under the effect of the use on the market as well. So to me, it's not clear that that's completely separate. That's just a minor point on your diagram there. But.
Oh, okay, I'll take that as a friendly amendment.
Friendly amendment, yeah.
Yeah.
So this probably should come out of it, Glenn, but in looking at your proposal, it seems your concern is on behaviors that will maximize the values we have and want the copyright system to support and incentivize. But you're focusing only, it seems, on those sort of generative acts as opposed to promoting those, as opposed to also using fair use to stop bad copyright acts. And so this is where this ties into what Glenn was just saying. I wrote a piece about presumption of fair use against copyright trolls. I'm sure there's other examples too. So why not bring that into the analysis? right? And the concern with the reason I have a presumption of fair use against copyright trolls is they're undermining a copyright system on the whole. They're making it so people don't want to create. They're making it so, generally the values of the copyright system are not being supported. They're sort of inverting copyright to profiteer, but not to use it for copyright purposes. I'm sure there's other examples that would sort of factor into the same anchor you have in this.
So, and I'm afraid I'm not entirely following you. The idea here is that there's some kinds of fair use that we have out there right now that ought to be there because they're not doing what we want them to do. Yeah, I entirely agree. We have there also a section where we take apart some of those, and so the ones that are outside of our presumptive grant of a privilege to the public, yeah, there's no reason to protect them under fair use. Is that
no? My point is sort of the opposite. Is that I think that you can bring under the presumption of fair use a user protecting measure that discourages bad copyright behavior by copyright owners, not just privileging certain copyright uses, but also using fair use to discourage certain copyright behavior by copyright owners that harms the copyright
I
system.
need to read your piece.
Okay, I'll
Yeah.
okay, sorry.
Yeah.
So I'm wondering how general do you want the second stage of the examination to be? Are we talking about with Texaco? Are we asking Texaco specifically is doing what they're doing? Will that drive out of business that specific journal? That's a very narrow question. But I think usually we ask a much broader question when we talk about market on, and that's trying to get tricky, right? We usually ask if everybody will do what Texaco is doing, right? First of all, we assume on the defendant side, everybody will do what they're doing. I mean, that's Supreme Court that's what we should do, and I think we should do that unless you disagree. We should have said everybody is doing that. No, we are not just limiting ourselves with this plaintiff, this defendant, one-time interaction, right? We ask ourselves if everybody will do that.
We're asking this type of use, but we are asking this type of use for this work, not for all works.
Okay,
Right?
and then we ask ourselves, but on that specific plaintiff, that's the argument. So
No,
this
type of
because at the margin, of course, it will drive out people out of the business.
It's
right?
this category of uses for this work.
Oh, there's a really interesting distributive effect, right? If you are a very rich plaintiff, you will lose those cases. If you are very poor, you will win them. Right?
No.
You don't.
I've heard about this.